This is Jason Sutton, the CLE Committee Chair. Thank you all for joining us for our August Law for Lunch. Let me know, as always I tell people, we're working through the technology issues, so I welcome input and comments. Does this work? Does this not work? Please let us know. Also, you'll see on the side there is a chat and a question icon that you all should be able to input questions as we go. The one downfall of this format is that other than the organizers, I think the participants are all muted. So if you have a question, please email the question. I'll moderate to best I can here and get an answer from our speakers. And at the end, there will be a chance to pose some additional questions. With that, I'm not going to waste anyone's time, and we're going to get right into the program. We have two members actually of my firm who are gracious enough to address what I think is perhaps an interesting change foreshadowed in the law governing closely held corporations. John Mullen, one of my partners, and Corey Denovan, an associate in our firm, have some great material to cover, and I'm going to shut up and let them talk. So I'm turning the floor over to both of them.
All right, this is Corey Denovan speaking, and the fact of the matter is this is not going to be a polished presentation, and John and I might talk over ourselves once in a while. We had this issue, this shaver case that came up, or that was published a few weeks back, and the buzz. Scandrit, I'm sorry. And the business committee took a look at it, and we had a heated discussion in the business section meeting what it meant, and so we thought it'd be a perfect subject matter for this Law for Lunch little CLE. The first slide that I want to show you is the takeaway points. What I want you to understand as soon as you when you hang up the phone, what you're going to walk away with, the major points. First and foremost, I want to make clear when I talk through the cases that we have scheduled to talk about today, think of shareholder oppression claims separate and apart from breach of fiduciary duty claims. It's really important that as you go through these materials, as you read the cases, that you really separate in your mind right off the bat the shareholder oppression claims, which are equitable, are different and separate and apart from breach of fiduciary duty claims, which are legal. The case law is developed enough at this point, we believe, that we know that there's going to be a different standard of protection for shareholders who are the initial shareholders of a company who invest their capital into a company. We're going to protect those individuals' reasonable expectations. And those shareholders who receive shares by gift or inheritance from the initial shareholders, those people, if they're going to bring a shareholder oppression case, must show that there's inherently oppressive conduct by the majority shareholders if they're going to be successful in their shareholder oppression case. Now, what's not as well settled, but John Mullen may disagree with me, is that there may be, or probably is, a different standard of care in a breach of fiduciary duty cases as it relates to shareholders who invest capital into the company, which they'll enjoy the highest degree of good faith and fair dealing, and those shareholders who receive their shares through gift or inheritance, and they might be only entitled to a decentness standard of care and conduct from the other members. How this relates from a business planning, from an estate planning perspective, you attorneys are out there practicing, should we be thinking about these issues in advising clients prospectively and creating a company that, if shareholders receive shares by gift or inheritance, they're going to have a more difficult burden with respect to a shareholder oppression case, and they may not enjoy the same fiduciary duties from other members. So do we have to think about this? Should we be advising about this issue when we're creating a company? And it's not uncommon from an estate planning perspective from individuals that are starting a company to put their shares or transfer their shares into revocable, or even more so now, irrevocable trusts. And does that change the standard of care? That's an interesting question that we need to think about and advise about when we're doing estate planning. can we address, one of the questions that we had in our business section was, can we address these issues with respect to existing companies? Can you draft around the results that we're going to talk about from these cases that we're going to talk about? And then the last thing that I would like you to think about as you read through these various cases is this good public policy where we're lowering standards, where we're changing standards of care for those individuals who receive shares by gift or inheritance? Are we devaluing shares of stock, and are we frustrating the intent of the entrepreneurs out there that are starting and creating these companies? These are just some thoughts that you might want to go through or have while you're reading these cases. And next slide, please.
Assuming I can get it to progress.
Well, while you're doing that, one thing, this is Mullen talking, one of the things that first strikes me about the idea of advising clients on the front end, I think these cases that talk about the potential difference in duty, depending on how the shareholders acquired their shares, it's significant in this regard. When you form these corporations where all the clients come in, I think one of the first things you have to talk about with your client, as we all do, and I think we kind of sweep this under the rug periodically, is who is our client when these disparate types of folks come in and want to form an entity and go forward. A lot of times you'll see there's the brains of the operation, there's the guy that has the money or the gal that has the money, and you've got a relationship, or someone in your firm has a relationship with one person but not the other. Who's your client? Is your client the corporation? Is your client the money bags? Is your client the brains of the operation? And that's a difficult conversation to have with your client, because it puts people on edge right out of the gate, that this guy's not looking out for me and that kind of thing. Are you ready? Something you're good? Okay. So I think these cases kind of not only, they aggravate an already complicated situation when you're trying to advise the clients or the people involved in the operation who your client is, because now I think you do have to advise them as you're forming these governing documents. Whose interests are you trying to protect? Because if you're representing the money bags and he's your long-standing client and you want to announce that he's going to be your client and you confirm that, and then going forward you're not the corporate lawyer, that you're the money bags lawyer, do you have to then, can you prepare documents to protect his expectations that when he begins in estate planning or she begins in estate planning and transfers these shares to their children or grandchildren or what have you, is he prepared or she prepared for the fact that there could be then a lower standard to those shareholders when they engage in that type of estate planning or business planning? So I think that this is just one more thing to talk about at the front end, which is unfortunate because it puts people on edge. It's another example where you have to tell people that you're not going to be in love forever, you may not be in love forever, and there's risk to that, and we got to talk about this stuff now where your interests may diverge. And clients don't like to hear that at the first people don't like to hear that at the first meeting. So that was one of the things that crossed my mind right out of the gate on a kind of a drafting and just, day-to-day trying to get through the practice of law business, is how you advise these folks on the front end. So that's one thing. Sorry, I kind of threw that in simply because we were having some difficulty, but it was important to me. So now, having said that, move on.
And I appreciate the patience with the people with my technical difficulties here. John and Corey have now framed the questions. Let's talk about the law a little bit and lay the framework a bit here for those that may not be as familiar with these cases as you guys are. So with that, we have the right slide. Turn it back over to Corey.
Okay. So the first case that we went back to was Landstrom v. Shaver, which is a 1997 South Dakota Supreme Court case. And as you read Landstrom v. Shaver, there's both shareholder oppression issues, and there's also breach of fiduciary duty claims in that case. With respect to the shareholder oppression case, the South Dakota Supreme Court relied heavily on a New York case called Gimple versus Bolstein. And I've given you the citation in this slide, and I highly recommend that as a first matter of business, start with reading Gimple. Landstrom will make a whole lot more sense to you when they talk about the shareholder oppression aspect of the case. The next case that followed up on Landstrom, I think, with respect to shareholder oppression is the Muller versus Cedar Shore Resort. That's a 2002 case, and that applied Landstrom and the Gimple thoughts to shareholder oppression. They also, again, talked about the standard of fiduciary care or fiduciary duty between shareholders. Then, of course, the most recent case was the Schultz versus Scandrett decision, which is significantly complicated by virtue of this procedural history and the fact that it really relates to a confusing jury instruction that was given.
Can I jump in there, Corey? One
Sure.
thing, it's on the slide there, but it is important to note, and we made sure we cross-checked this in the earlier cases. Well, the Business Code, Business Corporation Act switched around in 2005, I think. So the statute that was under review in Landstrom and in Cedar Shores, it's largely the same. It's not identical. It's moved. 47-7-34. Excuse me. 47-7-34 is moved. I think we got the new site. Yeah, we do. So that's where it is. There are modest differences. At least in my opinion, they're modest. But you know, it's all the beauties in the eye of the beholder. I mean, if your case, I think you need to look at those issues and make sure you're looking at the right statute presently. So the oppression statute, if you will, that was under review in these cases that we've cited has moved. And make sure you're looking at the right statute when you are examining an oppression case. And keep in mind, I'm going out of order, but I got to get this off my chest. I mean, the statute that gives rise to the oppression cause of action is statutory, of course, but it doesn't create the equitable remedy of shareholders buying and selling each other out of an oppressive setting. The statute gives the trial court the authority to dissolve a corporation when those findings are met. There's 4 different types of things. That's important. And the Landstrom case, though, did clearly recognize that the equitable remedy that the trial court has the authority to do, short of dissolution, is kind of a mandatory buy-sell arrangement. And so you always got to keep your eye on that ball. Is if you're bringing a case for oppression on the statutory scheme, I mean, the end game can be, under the statute, be the dissolution of the corporation. But in any event, the statute's still out there. It's just moved around, and you just got to keep your eye on whether or not the changes are significant for you.
Okay, so moving on to Landstrom versus Shaver. I'm not going to get too bogged down in the details, the facts of the case, but with respect to the shareholder oppression, they defined it in the context of either or they laid out sort of a 2-tier test. That you either have the conduct that substantially defeats the reasonable expectation of the minority shareholder, or inherently oppressive conduct, which is burdensome, harsh, and wrongful conduct by the majority shareholders. They got this test, or the South Dakota Supreme Court adopted this test from the Gimple decision, relied on the Gimple decision for that. And Gimple, when you read the Gimple decision, what you'll find out is that they viewed these 2 different standards, if you will, as different sides of the same coin. It's a matter of perspective, whose eyes you're looking through. And Gimple, they lay out and they explain that the first test, the conduct substantially defeats the reasonable expectation of the minority shareholder, really relates to the initial shareholders, or the shareholders who contributed money to the corporation to start the corporation. That's the test that you look to, whether or not that individual has been oppressed. And you look at the relationship in light of the history between the parties to start that company, and whether or not their reasonable expectation as to how that company would be run or operated or managed has been frustrated. Now, when you have older companies in which shareholders receive their shares by bequest or a gift from other parties, the second test is more appropriate, because they don't have those same expectations, if you will, or understandings as those individuals that started the company. And so those shareholders that received their shares by bequest or gift, they have to show that the other members' conduct was inherently oppressive, which means burdensome, harsh, or wrongful conduct by the majority shareholders. And what's important to point out here is that Landstrom v. Shaver, they had this shareholder oppression component to it, but they also had breach of fiduciary component. And when they discussed the breach of fiduciary duty part of the case, they left untouched the standard of care that the individuals owed to one another. They recited the highest duty of good faith and fair dealing, but they didn't talk about any bifurcated standard as with respect to the fiduciary duties that the individuals owed to each other.
Right. The Supreme Court, in a sense, didn't feel like, it seemed to me that it wasn't necessary. The Supreme Court in the Shaver case, the Landstrom case, in my opinion, essentially accepted the trial court's decision that there had been some sort of breach of duty by Mr. Shaver when he allegedly concealed that special veto power he had when they did the amendments to their buy-sell agreement. But they then concluded there was absolutely no causal connection to any damages, if there were any damages. I think they said there weren't any of any kind, because the veto was never exercised. Mr. Shaver was dead. So there wasn't a ton of analysis and didn't need to be on the fiduciary duty in Shaver, because it just didn't seem to be critical. And the two-test thing, I just want to emphasize the two-test analysis, what I call the reasonable expectation test and the decent test, those two different tests. That was all, again, just for, it's worthy of repetition. It's in the oppression component of the counts that the plaintiff brought. And I don't know, Corey, if now's the time, but I mean, it's important if you're going to be litigating these cases to recognize this severance concept. Now, Judge did allow the trial, in that case, the equitable claim and the legal claim for breach of fiduciary duty were tried at the same time, although there was an advisory jury on the equitable claim. But we're going to, the footnote 1 in the last case we're going to talk about, Scandrett, raises this issue of have we blurred the distinction and significance between the legal claims for breach of fiduciary duty and the equitable claim for oppression, and is there a renewed significance as a result of the Scandrett case in trying to keep those separate and keeping your eye both on the facts that support the claims, the legal consequence of bringing one versus the other, all the way from the standard of care to the burden of proof to the statute of limitations to the remedy that's available. All those things are significant depending on which theory you're picking. So I sidetracked you again, but I think it's important that Landstrom had both counts. They were tried together, and judgment was entered on both counts in favor of the plaintiff in that case on both theories.
And John, correct me if I'm wrong, but my recollection of Landstrom is that, you know, the Supreme Court reversed and remanded, and at least as it relates to the oppression, it found that the facts didn't support oppression. But then as it relates to the breach of fiduciary duty case, they found there was a breach, but there was no causation and damages, which would indicate that they were separate. Am I wrong on that? That there were different standards?
I think that the Supreme Court in Landstrom v. Shaver, I thought, affirmed the judgments at the trial court level in favor of the plaintiff on both counts. There was some remediator going on that there was duplication and damages, but I'm pretty sure the Supreme Court affirmed both the oppression and the fiduciary duty. But I do agree that there was no, here's the point that I take away from Shaver, that in analyzing the fiduciary duty legal claim, the Supreme Court did not engage in this, there's a lower duty to shareholders that receive their shares by gift or otherwise. That kind of disparate testing only occurred and was only discussed in relationship to the oppression equitable count. So do you agree, Corey?
Yes, absolutely.
Right, okay.
Absolutely.
Right.
And thanks for proving my point indirectly with me being wrong.
No, I didn't say I was right. I think I'm right. All right.
Move on to Cedar Shore.
Okay, so Mueller versus Cedar Shore. I wanted, when you read that case, I think what you want to take, one of the things you want to focus off right off the bat is really the Supreme Court was focused on this economic approach in shareholder oppression cases, where they really were focusing on trying to protect those individuals that contributed capital to the enterprise. And again, as with respect to the shareholder oppression component of the case, it reinforced, restated sort of the Landstrom v. Shaver analysis that the court's going to consider the reasonable expectations of a minority shareholder if you committed capital or entrusted your money to the company. But if not, then if you're going to bring a minority shareholder oppression suit and you receive your shares by bequest or through inheritance or gift, then you've got to show inherently oppressive conduct, which is burdensome, harsh, or wrongful conduct by the majority shareholders. And one thing that came to my mind when I was reading Mueller was that what about those individuals that didn't maybe commit capital to the enterprise, but nevertheless were involved in it. They contributed sweat equity or intellectual capital to the enterprise, and maybe they didn't take as much of in the way of a wage or anything like that, with the expectation that they were going to get a share through inheritance, perhaps shares of stock through inheritance or through gifts. Shouldn't they receive, those individuals receive their reasonable expectations be defended in a shareholder oppression type statute? So then moving on, there, like I said, so that was the shareholder oppression part of the case. There's also the breach of fiduciary duty case, a component of the case in Mueller. And this is where the court said, you know, that individuals who contribute capital to the enterprise or start the enterprise, they get the highest degree of diligence and due care, as well as the exercise of utmost good faith and fair dealing in their breach of fiduciary duty cases. But they went on to say that if you were gifted or inherited shares of stock, that maybe your only expectation was a decentness standard of good faith and fair dealing, which is a lower standard, if you will, of fiduciary duty that you can expect. So now we have a change in the law, so to speak, with respect to the breaches of fiduciary duty. Do you have anything to add to that, John?
Well, I don't. Other than it's interesting then what happened to Mueller versus Cedar Shores in footnote 1 in Scandrett. We'll get to that. But I guess I want to say that when I look at paragraphs, you know, I'm not an expert on this, but paragraph 25 of the opinion, I'm talking about the Cedar Shores opinion, 25 through 30, the Supreme Court's clearly analyzing the breach of fiduciary claim. And when they did that, they go through the secondary source, the treatise, the Hamilton treatise, which is heavily relied upon. But I think that's when they begin to introduce into the fiduciary duty analysis this dual testing, and that there's a lower standard in closely held corporations that have shares that have been received by gift. And I do believe, and I mean, I don't know how else to read this, but when you read particularly paragraph 28, the scope of the fiduciary duty owed by a family-owned corporation that has gifted its shares to the shareholders is somewhat more limited than that duty owed in the context of the traditional closed corporation. That is squarely within the fiduciary duty analysis of the court's opinion. The paragraph ends with, on this duty, fiduciary duty, the question is whether or not Paul and Mary Pat, the plaintiffs, had identified sufficient evidence to demonstrate that the conduct of the individual named directors, skipping a pit, amounted to something below the standard set forth above. And that set forth above is in the oppression analysis. So in my opinion, clearly in this case, the decentness standard that originally was introduced in the oppression count has now made its way into the fiduciary duty.
So at that point, I mean, do you guys read Cedar Shore that there was any difference for minority shareholders who'd received their shares through gift or inheritance in the breach of fiduciary duty standard versus the oppression standard? Are they essentially the same?
My read is that they're the same. I mean, that's my, now I question that in light of Scandrett, but after Mueller versus Cedar Shores, I felt that the equitable count and the legal count would apply the same decentness standard to shareholders that receive their shares by gift.
And there's our lead-in. So what did the Supreme Court do in Schultz versus Scandrett that brings us here to talk about this today?
So in Schultz versus Scandrett, we have a breach of fiduciary duty claim, and there's a jury instruction that's given on the breach of fiduciary duty claim, but it discusses the standards set forth in shareholder oppression cases.
Well, the instruction didn't, the decision does. I mean, you know, I'm just trying to be clear there. You say it discusses the standard from the oppression. The jury instruction did. No, the jury instruction says that Lyle could not, Lyle was the target defendant, right? And that Lyle could, well, we just read it. The fiduciary duty law can't be used in South Dakota to compel Lyle to walk away from a compensation agreement they had with the corporation.
Right.
Right. But the parties in the court then used some of the oppression analysis to determine whether or not that instruction was correct.
And what's interesting, in footnote 1, the Supreme Court said that it questioned the parties extensively as to why they were relying on the standards set forth in the shareholder oppression cases for the breach of fiduciary duty.
Right. That's right. I agree with that. Maybe I misunderstood what you said, and I think I did now that I'm looking back on it. Now, how much, are we okay on time? Because I want to mention something here. I did visit with Jeff Hurd. Jeff was the counsel for the Scandretts and his daughter, Lyle Scandrett, and his daughter in that case. And I was curious about why, quite candidly, I was just curious about why instruction 19 was given in the case. And Jeff confirmed for me what I kind of anticipated the answer might be, but I'm sure he would say it more artfully than I'm going to. But what happened in that case was that Lyle was the target defendant, that his fiduciary duty obligation, essentially, as I understood the plaintiff's argument, his fiduciary obligation to the corporation, whether as a majority shareholder or as a director, would compel him to relinquish a contractual arrangement that he had created with the company that put him in that position. In other words, before he had a contract for employment and for compensation and for majority ownership, that was the result of discussions that, hey, if I'm going to stick around, I need to be in this position. And this is the pay that I want to stay in that position. All right, so then does he have a fiduciary obligation at a later time to walk away from that voluntarily simply because maybe circumstances had changed? So instruction 19, if I got the number right, the one that was under review by the Supreme Court, was put there on the theory that, hey, the plaintiff can't use fiduciary duty law to compel Lyle to walk away from a contractual relationship that was negotiated by everybody involved, including the corporation and its shareholders and the successors to the then plaintiffs. And I think, so that was it was a fiduciary duty analysis. But yet the parties that briefed it and the Supreme Court, I think, analyzed again this concept of the oppression, just like you said, Corey. But then the Supreme Court questioned this kind of, in footnote 1, what was the word? I don't want to call it, I think they use suspect. Did they use the word suspect reliance on the oppression? Yeah.
Yes, exactly.
So if they use the word suspect reliance, and I think, to me, well, as a lawyer, I know why they argued it that way, because that's what Mueller told them to do, in my opinion. All right, that's my opinion. That's what Mueller did.
So let's step back and set the stage a little bit for those that may not have read the decision yet. In Schultz and Scandrett, as I understand it, John and Corey, correct me if I'm wrong, we had a jury trial, and the issue on appeal was the instructions provided to the jury on the breach of fiduciary duty claim. Because remember, only the oppression claims an equitable claim to the court, so it's not going to be tried to the jury. So in doing so, the court was then forced to analyze the application, of these oppression principles, whether it was a correct statement of the law for the breach of fiduciary duty claim. Is that really the context that we're there?
Yeah, I think that's true. Yeah, I think that's right. And the parties then briefed it and argued it that way, I guess, and the court analyzed it. And I didn't write the footnote. Justice Wilbur wrote the decision, and the footnote says what it says. You can try to interpret and guess what it means, and my take on it is that it's questioning, in all sense of the word, the blurring of the distinction between the two different counts. Meaning, maybe be more careful on what facts support the oppression case. Be more careful on what facts support the breach of fiduciary case. Be more careful about combining them and trying them together. Be more careful about the remedy. Be more careful about the standard, and pay more attention to the distinction between the two. I feel that it's reeling back a little bit the Mueller decision and the paragraphs in that decision that I identified in particularity with where they introduced a decentness standard to the fiduciary count in the Mueller decision. I could be wrong, obviously, but I think that's kind of what's going on in footnote 1.
Do you think they're suggesting that the standards are the same, or are they not the same, or do we not know?
I think it's a suggestion that fiduciary duty standards prospectively is a fiduciary duty standard, and that we should rethink, and perhaps there is no difference there is no lower fiduciary duty standard to people that receive their shares by gifting, or we should revisit that issue. I could be totally wrong, but I can't. Why? I guess I hate to say it, but why else would footnote 1 be in there if the court wasn't questioning the reliance on the oppression analysis when discussing a fiduciary duty jury instruction.
How does that square with what the court did in standard? Because they ultimately affirmed, right?
Well, not very squarely. I don't know. I think it is. It is. I think it is a revision, in my opinion. If I'm reading footnote 1 right, I think it's a pullback.
So the takeaway is go read footnote 1.
I think a person should spend a little time thinking about it. But again, I think it's not just perhaps I'm overemphasizing the distinction between the legal count and the equitable count just on the standard. It may be focusing more upon trying them separately. It may be a suggestion we should pay more attention to trying them separately. It could be pay more attention to the remedy, because again, the remedy is significant. And you know, we know that it's interesting to me in the equitable count. It does say that whether or not conduct, I think both Landstrom and Cedar Shore said this, whether or not conduct amounts to oppression is a legal question. Whether or not there's a duty and the scope of that duty and the fiduciary duty is a legal question. But the cases do say these words, that whether or not there's been a breach of that fiduciary duty is a question of fact. And we all know what that means. If there's good stuff for a judge to hang his her hat on about whether or not it should go to the jury, questions of fact are more likely to go, I think, than legal issues that are clearly for the court. So I don't know if I don't know if I'm overemphasizing the footnote for the what the prospective application might be, but I think it's all the issues we talked about. It could just be more careful about the facts that support each count, be more careful about trying them together. But I think it's to the duty.
I think speed things up. Let's get to the issues that we need to think about as lawyers in light of this, and perhaps the Supreme Court muddying the water. Is it the same standard? Is it not the same standard? Does anybody know what the standard is?
Well, I think the important, my thought is, if I've got a client that comes into my office and is complaining about activities of the company and they might be oppressed, or whether there's a breach of fiduciary duty, I need to figure out, how did they receive their shares? Did they receive? Are these individuals that were the start of the company, that committed capital, that entrusted the money to the enterprise, or did the client inherit shares or receive gifts of shares? And in that case is going to drive the standards that they're going to be up against in a shareholder oppression case. Clearly, in those types of cases, we're going to have they're going to receive two different types of treatment depending on how they receive the shares. And then even in a breach of fiduciary duty, if they're going to go back to the Mueller decision, it may be that there's two different standards of fiduciary care that we need to be mindful of here and be concerned about. So that, I think, is the first and primary issue. And then, you touched upon, John, at the beginning of this conference call, is that, when you're setting these companies up prospectively, how do we deal with this? Should we be dealing with having a discussion with your client?
Right. It's hard enough, from my experience, it's hard enough to get clients at the outset of an enterprise to pay any attention to what you have to say and issues and duties. But now to further complicate it and say, oh, by the way, 3 generations down, you guys got to think about, what this duty analysis might be if you guys begin to engage in estate planning and gifting. It makes the job hard, but I think you have to talk about it, and I think you probably ought to be in some sort of retention letter about the issue of you got to be mindful of the fact that if you engage in this stuff, the duty could switch. And which, by the way, is one of my big beasts with the whole shoot match, is that they talk about the reasonable expectations even in the higher duty and the oppression. What's the reasonable expectation test? I think that's what perhaps is getting thrown out to the curb on these deals is, for example, Ivan Landstrom in the first case. I mean, that was his baby, right? He died in the plane crash with a lot of young women and other folks. So, and his, do you think for a second his expectations were that when he died and those shares transferred to somebody in his family, that they would receive a lower duty than what he would have been entitled to as the owner? I mean, it seems to me his expectations almost evaporated upon his death. And I have a problem with that, because you mentioned that. These are the entrepreneurs, these are the brains, these are the money, these are the people that put it together, and now all of a sudden it's different. I don't know if I agree with that, but that's maybe a different issue. Let's see, we're probably running out of time. One of the things, Corey, I think that we talked about, and in the buy-sell situation, and we may outsmart ourselves. I have not gone to anybody in the CPA world that does evaluations and ask them this question. But as I began to think about what the hell I was going to say for a while here, one of the things that crossed my mind is, does the fact that these minority shareholders, I mean, this is going to be a bad sentence, but does the fact that minority shareholders may experience a lower duty to them, does that impact the value of their shares? I mean, if you can be moderately oppressed, I'm making those words up, nobody's ever said they can be moderately oppressed, but the standard's lower.
Sure.
So are your shares worth less than the person that's still the original entrepreneur that invested capital? And could you convince the IRS when you do your discounting for estate planning? Could you convince the IRS that the standard discount's 25, 35%? We can go 40% under South Dakota law because the shares I'm gifting, they're gonna the minute I gift them away, they're not going to be worth as much because now they're going to get a lower standard of care. I don't know. I mean, that could be too much lawyering and ivory castle crap, but I think that if you can be treated differently, how could they possibly have the same value?
Absolutely.
Well, let me ask you this. I mean, John, you talked about at the beginning, you know, do we need to tell our clients, the money man, the idea man, you know, the effect that this may have on future gifting and the duties for purposes of the creation of the organizational documents? Doesn't that beg the ultimate question? Can we draft our way out of these standards? What do you guys think?
Well, I think that brings me back to the Landstrom case. You know, Ivan Landstrom dies, his shares get transferred into a trust, and ultimately are distributed, the shares are ultimately distributed to his kids. The kids, his two children, and the other shareholders enter into a shareholder agreement, presumably discussing how they're going to be operating the company, whose rights, who gets what, and so on and so forth that we handle in shareholder agreements. But then those individuals, because they did get their shares through inheritance, it seems to suggest that they were treated to they had to show inherently oppressive conduct. They weren't, their reasonable expectations weren't defended at that point.
Well, if I hear you right, in other words, notwithstanding the fact that when the shares that were originally in the Landstrom Trust went to his two daughters, they were mature adult women, probably represented by counsel, a new deal buy-sell agreement is struck, and even later another amendment to the buy-sell agreement is struck, all while there are people paying attention to their affairs, and yet the law is that somehow those women that receive their shares through dad's trust will receive a lower degree of care. That troubles me, but that's the result of those decisions. So can you draft around it, Jason? I suspect the answer is, I think the answer is yes. I don't think it's, I first thought about, well, I feel like I'm trying to get one of those pre-injury releases and waivers, you know, and those are, I know we got case on that from the softball case, but I think this is different. This isn't waiving a claim, it's like the opposite. It's agreeing that the standard of care that we're going to provide to our shareholders is at a certain level. And then and we're not going to drop it down depending on how you got it. I guess I don't know why that wouldn't be enforceable. If I have an employee manual that gives rights that exceed federal law or even common law, I mean, that's still a contractual relationship that if it's more protective, why couldn't you do that? So I think, Jason, my answer is you can. The question is, who's your client, and do they want to have that level of protection to be maintained? And I think it depends on who your client is, and then projecting what the future is going to look like, which makes it kind of hard to do.
Before we open this up for questions from the group, I have Corey, and for those that don't know, Corey's practice is primarily estate planning. Let me ask you this: how does this play with creating a, for instance, revocable trust, living trust, irrevocable trust? Do we have any idea what happens to the duties when you start transferring shares into trusts for gift planning purposes, for estate planning, any of these other, rather than the simple, hey, I die and I will it to John?
Well, yeah, I think that's the question that the South Dakota Supreme Court raised in Scandrett explicitly. They said, who is an inherited minority shareholder in these situations? Because you did have Don, I think I have it on a different slide, I kind of diagrammed the relationship between the people, but Don and Eloise had gifted shares of stock in the company to the Schultz Family Trust. and is that Schultz family trust a inherited shareholder? And the question's in my mind, well, does it matter if the grantor that funds that trust is the trustee of the trust? Does it matter if he's a beneficiary of the trust? Do those change the facts and whether or not they go from a more protected shareholder status to a lesser protected shareholder status? I don't know the answer to that, and it didn't get answered in the Schultz case, quite frankly. So we don't know, but I think when you do go into these drafting strategies, particularly when you're using the irrevocable trust, maybe you need to have that conversation with your client and how secure, how safe do they feel about their status as a minority shareholder, and what happens if these things get transferred, and what the outcome could be.
I don't know. My parting shot on some of this is that I feel that in these situations, both in Landstrom, not so much in Cedar Shores, but in Landstrom and Scandrett, I think there were contractual relationships between the players, the corporation, and for example, the buy-sell agreement. Those people negotiated that deal. In the Scandrett case, Lyle Scandrett negotiated a deal with the company. This is, I'm going to quit my job as I think he was an academic. I'm going to quit my job as a teacher, I think. I'm going to move on. I'm going to run this thing full time. But I'm going to do it, but I want a salary. They changed his compensation, and I want protections, and I'm going to be able to preserve that income. So they structured a deal. They negotiated a deal, and yet there's still claims that somehow that has to be unwound under these analysis. And I'm just somewhat afraid that it's the tail wagging the dog. I just feel that we got minority people running around telling the majority what to do, and it's troubling. And I don't know that you can protect yourself. Interestingly, the Hamilton case, the Hamilton treatise, we looked at that too. The Hamilton treatise, Jeff Hurd actually sent it to me. I took a peek at it.
Hamilton is cited in
well, it's not Shaver, right? Lance Rivers Shaver didn't cite it because I think his treatise came out in 96, but the other cases cited, yes. So Hamilton's treatise is cited, but some of his analysis on this fiduciary duty is, is there a duty in corporations? If you want duties, be a partnership. You want to be a corporation, majority rules, and yet that majority rule in the corporation has kind of lost its luster. So I think it's pretty safe now that in South Dakota there is not only a duty from a majority shareholder, so Corey, I own 70, you own 30, I owe you a duty. But if each of us, the three guys in this room, Sutton, Denovan, and I, and you guys work as 60% owners against me, you're working in concert, you owe me a duty. And I don't know. I mean, I think that's the law. But.
Are there any questions? When we started this, and I've asked a few as we've gone along, we're getting close to our time, but we've got a little bit of 10, 15 minutes. On the side, there's a questions bar. You should see this toolbar, if you will, and questions can be typed in. I know that one question that was asked is whether the slides will be available on the bar website. I'm going to defer to Nicole on our capabilities of that. Assuming that we can accomplish that, we will do that. Otherwise, I'm speaking for my presenters, and that if anybody wants to see them, we would be more than willing to provide them. There's a lot of detail on the slides. But are there any other questions, comments? These guys will talk forever about they don't know what the law is.
Yeah. I do know what the law is on one point.
Hold on a second. Okay, here's the question. It seems that the duty owed is contingent on the risk assumed. How would you guys respond to that thought?
I think there's some support for that. I mean, if the risk is the financial risk, I think there's support for the idea, because the economic approach, that if you're investing the cap, presuming I'm understanding the question, if you're investing capital and you're dropping what you're doing to try to make this thing go, then you're going to get that reasonable expectation test, which is the higher standard. But those expectations have to be known. They can't, like in the parting shot in Lance Rivers Shaver is your subjective dissatisfaction with how the management of the corporation isn't satisfactory to prove oppression, and she got zipped on both either the higher or the lower case. So I think it's probably, don't you, Corey? I mean, the whole idea is if you're investing the capital then you're going to get the higher test.
Yeah, and the idea, I think, the principle that I see through these decisions is that we're really going to protect the individual that two guys go into business with one, or let's say three people go into business with one another. One of them dies, his shares go to the next generation. They don't want that next generation really affecting or tremendously influencing the operation of the company by the two individuals that were the initial investors in the company to get it off the ground.
Right, protecting their expectations. But
right.
My point is the expectations of the guy who happened to be, unfortunately, the first to die, his expectations, I think, arguably are thrown to the curb, because now his beneficiaries of his work, his entrepreneurial spirit, his capital are exposed to a lower standard. And I don't know that that's what everybody's thinking when that is set up.
Well, I think you're right. And then what about that second, what brings to mind is, what about that second generation that works the summers there, that goes to work for the company, ultimately takes a lesser salary than they get somewhere else, with the idea, with the expectation that at some point in the future that one, they're going to get gifted the shares, or two, that they're going to inherit the shares. Should that factor into this? Are they truly inherited shareholders? And then the other issue is, what if you got a person that inherits a few shares and also buys a few shares?
Which are they?
Well, yeah, what are they on a shareholder oppression case after that?
First in, first out. Anyway, there's a comment we received, and I'm going to defer to the people that are I'm smarter on the drafting side, and you guys may or may not know this, but I think it's good for the benefit of the group. The comment was made is to keep in mind that if you're trying to draft around this issue in an LLC, you need to deal with the non-waivable statute in 4734A-103. I'm not going to put you guys on the spot, and I have no clue if that's right or not, because an alarm goes off, it helps when I draft documents.
Well, there certainly are. I haven't memorized the statute, but there are non-waivable provisions, obviously, in the LLC Act, and they do mention the duties. But I don't know that I have, what exactly, because I have the code book here. What is it? What's the statute number again?
4734-3.
I guess my question is, I'd have to read the statute again to determine when, I think they identify the duties created. In other words, they say the duties created in, and they refer you back to the duty statutes. And those duties are, they're in 830, 4718. That's a corporation, though. Sorry. Yep, 4718-830.
So be warned, if you're trying to get around this, got to deal with the other aspects of the code.
103.
Any other questions? For what it's worth, John, yep, our questioner relating to the expectations and the risk analysis agrees with you. And whose prism are we looking at? Which shareholder, the first versus the second? And I think the point is the court is glossing over all of that.
Well, I'm just real quickly, if there's a question, I'm looking at 103, and it does say that the operating agreement cannot eliminate the duty of loyalty, and that's kind of my point. Is if I was eliminating the duty, I think I tried to make this point earlier. If I was trying to eliminate the duty or alter the duty to a lower level, then I'd be more akin to those kinds of cases that say I want a pre-injury release. You're going to engage in this activity, and you're going to waive all your claims, and there's law on that, and it's kind of hard to do, but you can do it. Here, I'm not eliminating the duty.
You're maintaining.
In fact, I'm arguably maintaining it at a higher level than it might be under law, if that's what my clients want.
Right.
And then that begs the question, who's my client?
Mm-hmm.
Okay, I need to, this is a kind of a longer question. I'm going to try and see. Unfortunately, the format isn't the best for me to read this. So
Reduce.
The question is, the distinction seems to be between the original shareholder and the subsequent shareholder, who in the case received by gift or inheritance. Any thoughts about an original investing shareholder who creates an inter vivos irrevocable trust for the benefit of future generations, and their shares are sold to the trust rather than gifted? Is there a lower standard of care, and the trustee needs to be concerned about that in that case?
Maybe. Hope that was clear. Maybe, and you know, again, it depends. If let's say they do sell it on a promissory. It's common practice in an intentionally defective grantor trust, where the person gifts or lends, I should say, shares to a trust, and then the trust pays on a promissory note back to the grantor. Well, what involvement does the grantor have in that? Who's the trustee? Who's the beneficiary? I don't know. The question, the South Dakota Supreme Court left us hanging on that. We don't know. We don't know what the standard's going to be.
Someone commented that this is a good advertisement by the South Dakota Supreme Court for Keyman Insurance. It's probably correct.